Hey guys, let's take a look at some of the action that's happening today in the Richard Allen case. There's so many documents out there that thought why not try and pick them up and just look at them instead of describing them online, which is boring. So I have glanced at it as I was pasting it in, but most of the stuff I haven't read yet. So we'll look at it together and see what's up in this case. There's some serious bombshells out there from Allen's remaining attorney, Rozzi. So, all right, I'll probably have to switch around a little bit because some of this will be hard to read, but I've got another screen up. So on the docket, you can see some early action, and you see the tremors before the earthquake here. There's a transport order issued on the 26th. That ought to be Allen to come to the hearing next week. And then here's one right here. It's like, uh-oh, this volcano is about to go off. Verified notice of continuing representation. I'd been watching the docket and hadn't seen anything filed for anybody withdrawing. So it didn't happen for Rozzi at least. And we'll look at that. And then we're going to look at this motion to disqualify, because now, kaboom, this thing went off, and he goes off on the judge on why she should be off of the case. There's an order for a transcript, and oops, I can't even read the bottom of it. Oh yes, his motion for continuance. All right, yeah. So what Rozzi is saying is, I'm staying in this case, Judge. You need to get off of this case, and you need to not hear anything else until you've been, or you reboot yourself off of this case. So meanwhile, the court also has something to say and posted up some orders on the docket and actually issued decisions on some of the pending motions. Let's see what the court said. Court notes the following pleadings may be resolved without further argument or hearing. Defendant's motion for broadcasting order is overbroad. The court will consider broadcast requests by the media on a hearing-by-hearing basis. That's certainly reasonable. So they're denying that they're going to televise everything, but they're also not going to not televise anything. Of course, they were going to televise this last hearing, and that didn't work out. Defendant's motion to quash subpoenas requested by the state for Allen's medical and mental records is granted. The state is not entitled to such records. So here the judge is ruling for the defense and saying, we're not going to let you look at his medical records. I think that is, I think that was for whoever he's seeing while he's incarcerated right now in custody. Defendant's verified motion for immediate transfer of custody is denied based upon the state's response and attached affidavits. The defense multiple motions for a Franks hearing remain unresolved as the court is still reviewing the thousands of pages of exhibits attached to the motions, as well as the multiple hours of digital evidence submitted by counsel. The court will continue to review the same. Defendant's motion to suppress and supplemental motions to suppress, as well as state's responses, will be set for hearing upon resolution of the defense Franks motion. Prior to the scheduled Franks hearing, prior to the scheduled hearing this date, attorneys Rozzi and Baldwin advised the court they will be withdrawing the representation of the defendant. The court accepts their representations and orders them withdrawn from the cause. Counsel ordered to comply with the previously entered protective order on discovery and ordered to turn the discovery over in full to the state of Indiana to be made available to successor counsel. The court requests their cooperation with successor counsel in the best interest of their former client, but is not requiring that. The court will maintain the hearing currently scheduled for the 31st. So the successor counsel can appear. The clerk of the court is ordered to remove attorney Baldwin and Rozzi's attorneys of record in this cause. And I don't think that happened, but that's what the judge's perception of what happened was. So let me get some comments here. Are these the new attorneys or the ones that quit? I'm confused. This is one of the attorneys that was there, Rozzi. Okay, well, I'll show the documents here in just a minute. So there are no new attorneys. One of the attorneys who, allegedly quit, Baldwin, is not, his name's not on these filings, and you'll see as we go through them. But Rozzi's is, and he's saying, hey, you know what? I'm not going anywhere. I'm staying, and you get the hell out, Judge. It's basically the thrust of what we were going to be seeing. And another comment, this case will last forever. And you'll see Rozzi says, don't make that happen. Let me stay on this case. Let's get this case to the jury and get it over with. So, the judge said in court they would be withdrawing. They had discussions outside the court. Rozzi is PO'd. That is certainly true. That is definitely true. And I have to concur with this. Thor wouldn't stand for this. True. I don't know. This whole Odin thing is no longer perhaps the most bizarre thing happening in this case, as we will move on to more documents. Rozzi never quit. She asked him outside the court and he refused. Right. Well, we don't know that. Okay. Because how do we know that? Because I'm not even sure it's consistent with his filings, as you'll see. We don't know what she said, what he said, and all that, unless you were there, because none of us know that. So, but we'll see what Rozzi's account of it is. And I'll come back to your point here in case I'm wrong. My impression was he's basically saying, nah, I am staying on this thing. So we'll have to see about this, about whether you're right or not. But I think one of us will be on this, but the one who loses is certainly entitled to be confused by what is going on. All right, let's look at this motion for continuance, which is small on every screen I have. It's the shortest one, and it's the least bombshelly one. We're definitely going to hit the big ones I got of his, because I pasted those in just a few minutes ago. Here's his motion for continuance, and here what he's saying is, stop hearing things in this case, Judge, until you decide my motion for you to get the hell out of the court and let somebody else handle this case. So now comes the defendant, Richard M. Allen, by counsel, Bradley Rozzi, and respectfully request this court to continue the October 31st hearing. He's unable to locate any specific order wherein the court scheduled the initial hearing. There's no articulation exactly what in the world are we doing on the 31st. Maybe that's a fair point. But he does acknowledge there have been discussions between the court and lawyers regarding this hearing and the possibility of the court conducting a hearing on the pending suppression motions filed by defendant Allen. So this is pretty casual in terms of the setting of the motions. Court hasn't issued a motion, anything on the Franks, and that's fair because it is quite long. Supplemental motion for Frank's hearing, additional Frank's notice, and so forth and so on. But this is where the rubber hits the road, and you'll start, the bombs start falling here. But these are not the biggest, but they were pretty big when I looked at it a little while ago. This court ordered defendant Allen's defense team to cease all work on his behalf and therein prohibited counsel from engaging in preparation for the October 31st suppression hearing or any other matters associated with this case. That's weird. If you wanted them to stop working on a case because you thought there was some kind of sanction thing coming up, then I agree with them. You would clear the calendar for this sanction hearing, right? If you're telling them don't work on the case otherwise. So I see his point. Now, whether it's strictly accurate or not, how can we know? Because as far as I know, this order is not on the record, on the docket, I should say. I don't know where the court reporters were when any of this was going on. The court engaged in actions on the 19th, which resulted in the court ordering the oral withdrawal of Attorney Baldwin from this cause. Now, I'm going to tell you, that's really weird. I mean, I can see you throwing the person off the case, but ordering them to withdraw, when you withdraw is normally what you're doing. Okay. But we'll get a little bit more light on this. Okay. As we move forward, Attorney Rozzi remains the only active attorney of record in this cause. So right now I'm behind on the bet because here he's saying he's still the attorney of record. On or about the 25th, he filed a motion to disqualify, believes that a full and final disposition on the motion to disqualify should take precedent over the issuance of any rulings on the Franks motions and the other things. Now, full and final disposition on the motion to disqualify. We'll get to that motion to disqualify. So remember this, different states have different procedures for judges recusing or being disqualified off of cases. It's weird. A lot of times the person making that decision is the judge on the case. And this motion, as far as I can see, is filed in front of her. Now, I don't know what the judge is going to do with that. We have some procedures here in North Carolina that if the judge has to make some findings of fact and things like that, they can move that motion over to somebody else. But basically speaking, if they find it insufficient as a matter of law, they just go ahead and rule on it themselves. But I believe that the words full and final disposition on this motion is Rozzi saying that even if you decide not to disqualify yourself, you shouldn't hear anything else on this case until we litigate it further. And we'll have to see what happens with that. That's just an assumption. And trying to make sure I'm looking at the same document you guys are. I can read this one. Here is his motion to verify his verified notice of continuing representation. So here's where he's saying he's going to continue to represent. And we'll see whether I lose this bet, which has no stakes to it, other than the public shaming that Rozzi was concerned about. All right, here he is, Attorney Bradley Rozzi, counsel for Richard Allen, in support of his verified notice of continuing representation. He swears and affirms. He entered his appearance. We know that. The court communicated with the prosecutor, Rozzi and Baldwin, on the 13th of this month and ordered them to cease work on Mr. Allen's case. That's really interesting. It'd be very interesting to see what the court has to say about that, because that is strange. That, I'd wondered at one point if maybe they had a condition put on their representation that caused them to consent to this withdrawal so that his case could be handled better. And a thing like that would certainly put them into a box like that. So it all depends on the circumstances, of course, and what was really said. Anyway, they say the judge said, stop working on it until we get to court on the 19th. The chilling effect of the court's emailed order was essentially to strip Allen of his Sixth Amendment right to representation, and it disarmed the attorneys for the defense during the week leading up to the scheduled hearing. You know, certainly you can kind of see that point, right? Like, that's weird if it happened. Like, don't work on this case anymore, but yet there's a hearing coming up. Okay. That's weird. On the 17th, Rozzi requested a conference to determine what we, the court, prosecutor, defense counsel, are trying to accomplish on Thursday, especially in terms of what is expected of us while we're on the record in open court. And so the court said, okay, well, come on in to chambers at 12:30 on the 19th. And of course, we know that's when things went even more sideways. Let's see. Yeah, I'm going to need the bottom screen for this one. All right. So Rozzi and Baldwin appeared in chambers, as we know, at which time prosecution was present. So it was an ex parte. Attorney Rozzi is of the understanding that the court reporter secured an audio recording of the in-chamber conference, which took place in two parts. And that's very interesting because there is this order for a transcript. So if what occurred in chambers gets transcribed, then that would be very helpful to figure out ultimately for us looking at it, well, what really happened here, but also assuming this thing doesn't go the way they want and the judge stays on the case, you know, they're going to need that, either the judge to justify her decision or them to attack it. The court first conducted business as it related to several pending motions, communicated with the parties, issued rulings. I think that's what I just read out earlier with those basic rulings. Yeah, so there's another filing in which a comment in which Rozzi lists the reasons that the judge should remove herself, and we're going to hit that when I got that in this PowerPoint here. But here he is talking about this, and the court conducted business related to several pending motions. We read that. The court then read a prepared statement to the attorneys identifying various issues throughout the case in which the attorneys allegedly exercised gross negligence in carrying out their responsibilities as counsel. And then the judge suggested, according to Rozzi, that the attorneys engage in a discussion outside of chambers regarding the allegations. So she's saying, why don't you guys go out there and talk about it? They said, well, wait, what? What's the clarification on this? And the court says, you got two options. This is according to Rozzi. Either voluntarily withdraw and get out of the courthouse before the hearing, or participate in a 2:00 hearing where there's a media camera, national media, and law enforcement. Of course, they ask for that, I think. And the court would read the prepared statement into the record and then disqualify Rozzi and Baldwin in the presence of defendant Allen and his family and the general public. And see, now this is the part that's confusing to me as we move through this, is I figured a threat like that, because you can see this guy is not backing down. He's going to have this fight. I was surprised that he acquiesced to that in the moment, assuming that he did, instead of saying, Judge, you can't do this. And, you know, if you go through with this, just cancel this for today, Judge. We got to take the temperature down, because if you go through with this, you're putting the prosecution at risk here, because this is beyond the scope of what you should be doing. I'm sure they had some conversation like that, but it looked like tempers got up there. After waiting approximately half hour for defendant Allen to arrive at the courthouse, they communicated with Allen regarding the stark choice that the court had offered in chambers. And Allen reaffirmed his desire to move forward under their representation, which is easy to believe. In fact, they note in this footnote at the bottom that Allen even signed a letter saying, yeah, I heard about the pictures being stolen, but I still want these guys as my lawyers. As of October 24th, defendant Allen objects to the court's attempts to strip him of his current counsel. Let's flip the page here. Court had engaged in an ambush. Sorry. Okay. Why am I off the wrong one here? Sorry. That is weird. Well, anyway, I got the right one on the screen where you guys are. After speaking with Allen, they engaged, they returned to chambers, at which time Rozzi articulated to the court that the court had engaged in an ambush of defense counsel, entirely void of due process. And it says here, and that attorney Rozzi would withdraw his appearance. So see, he is saying here that he told the court. Now, granted, he's saying the circumstances are wrong, but he said, I will withdraw my appearance. So I think he did tell her he would quit. But he said my withdrawal is not a voluntary withdrawal because the court made it clear that if Rozzi did not agree to withdraw, the court would publicly shame him in front of the world and his client before firing him off the case. So, yeah, still, he did it. He quit. He didn't put her to the test of doing that. Now, of course, he's withdrawn his withdrawal later on, and I get what his argument is, but let's keep it clear which way this actually did happen here, I think. All of the events in Chambers occurred without any formal allegation of, let me get back here to the bottom, contemptuous conduct by attorneys for the defense without any pleadings requesting disqualification of defense. Yeah, I didn't see any of that either. And no disciplinary complaints with the commission. They've totaled practiced law for more than 50 years, never had a disciplinary action against them that was substantiated, it says. At no time while in Chambers did the court ever articulate to the attorneys that their conduct compromised defendant Allen's defense in any way. And Allen doesn't believe this to be the case. Well, I don't believe it to be the case either, of course. I'm not on their side per se, but I think they've been litigating this case very hard for him. Now, whether their conduct and how they handled the discovery material was appropriate or negligent or on purpose or these things, I don't doubt that they're trying to represent him the best they can and probably better than anybody else would have done if they'd been assigned to this case. So, and here's the question. Is anybody else confused? You won't be confused when we get to the final document. But so far, just to keep it straight, big blow up in the judge's chambers. The attorneys agree to quit the case, but they say that because the judge forced them into it versus the other choice that they had, then he changes his mind and says, no, I'm staying on this case. You get off of this case. And we'll get to the exciting conclusion of that pretty soon. Is this an oddity? Yes. Okay. Meeting in a chambers prior to hearing is commonplace from what I understand. That is true. I mean, I can't tell you how many times I've talked to judges before hearings and after hearings and things like that. If you go on Reddit, of course, that part in and of itself is completely shocking, even though this conversation was recorded. So the truth will come out if it needs to. So that part of it is not alarming. I understand the argument by the defense here, but I'm just going to tell you, while I respect it, I want to understand it, I don't take that as fact either, okay? Because you just shouldn't do that in anybody's pleading. So we'll see. Now, I do take as fact they were very upset with what the judge put to them, and the judge was coming with an ass kicking in this hearing. That's for sure. They didn't like it, but I have to also tell you that I thought a public ass kicking and maybe even some kind of sanction would not have been enough for them to say, we'll come off of this case. Now, granted, they're saying the judge was going to say, well, then you're disqualified off of this case, but I thought they would put her to that test. However, I was wrong, 50% at least, because now he's come back and said, no, I am staying on this case. So it's quite bizarre. All right. So let's see. All of the events and chambers, blah, blah, blah. No bona fide facts or circumstances wherein Rozzi engaged in any gross negligence. And I think that's what he said the judge was going to accuse him of. I think we read that earlier. Nor was there any showing that any conduct by the attorneys results in negative consequences to another party, i.e. defendant Allen. So they did nothing wrong to compromise his defense. Okay. And I get that. And I believe that. Having said that, okay, on the other side of it, if they're mishandling the discovery, and I'm not saying they did, but that was part of the allegations that were going to be discussed. If they're letting things get leaked out or leaking things out themselves or negligently doing it, you don't get to just do that because it doesn't hurt your own client. Okay. So now, having said that, Baldwin had told the court, look, if you want to punish me, make me work some time for free. So he wasn't saying don't do anything to me. If you really feel bad about this, judge, just limit what you do. And I kind of thought that's where it would land, but obviously cooler heads did not prevail. So let's read paragraph 14 here. Attorney Rozzi's oral acquiescence to withdraw his appearance as his attorney was forced, coerced, and driven only by the circumstances, which delivered two terrible options: quit or be shamed in public before being disqualified from representing Mr. Allen. If you already don't like this judge and you love the defense attorneys, then this sounds terrible to you. I don't. Paragraph 14 impresses me about as much as the paragraph they had in there where Allen couldn't cross the creek because he was 5'4". That's not to say they don't have good arguments and they don't have some points here, but not everything everybody on your side writes is great, and not everything everybody writes that's not on your side is great or bad either. And this he seems like a strong-willed person, and yet this paragraph suggests to me, like, what were you doing there, bro? Why didn't you just get in there and have a go at it? I mean, you've seen people do that before, right? So I don't know about that one. That seems kind of weird. All right, I still do have it on the right page. It's impressive. It was a premeditated ambush. Yeah, that's also what they say. And let's move it on down to 9. It was an impossible ethical bind. If counsel did not agree to withdraw in chambers, the trial court would publicly disparage their representation of the accused. Now, see that word he used there? If they don't agree, okay, agree. Publicly disparage their representation of the accused, framing their advocacy on his behalf as gross negligence, casting them into merits in a negative light. Now, okay, the part about his own representation being busted by the court, sometimes lawyers get sanctioned. They may not like it or whatever. It goes on the record. That shouldn't be a reason to quit your client. Now, he slides over to the other part, which I can see, which is saying this would cast the defense in a negative light, prejudice people against Allen, and we didn't want that to happen. And that argument I can respect. This public statement and circumstance created by the trial court is tainting the jury pool, which goes along with that argument, harming their defense, undermining professional relationship. Of course, on the other hand, maybe they needed a scolding for how they were handling discovery. See, Baldwin had some of that in his brief. He talked about how the leak occurred. It shouldn't have happened. They've taken all these mitigating standards. Anything you're hearing so far about, like, yeah, we're at least a little bit responsible for the fact that you were going to break one off in this, Judge? I haven't heard it here yet. And most things in life are not completely one-sided. So when you see a completely one-sided brief, you have to remember there are 2 sides in court at least, and you haven't heard the other side of it. And here there's going to be potentially 3 sides of it. All right, so the jury trial on this matter is set to commence in January, as we know. The appointment of successor attorneys will prejudice the defendant by and through further delays in his case and trial. But if he moves forward with his representation, he wants to stay in, there'll be no need for 2 newly appointed attorneys to dedicate hundreds and thousands of hours toward a mere review of the discovery. And that sounds crazy, but it's true. There'll be no need to marshal all the discovery and return it to the prosecution. And I fully agree with this. I was not on board with the judge potentially throwing these guys off of the case for these reasons, that there was a lesser sanction available. Baldwin even put it out in his brief. And it has the negative consequences that he's talking about here if they are taken off of the case. It's bad for Allen and bad for the victims in this case. So I respect what we got here. All right. Let's see. There'll be no need to marshal all the discovery. Now, here's the thing, though. I don't like these attorneys, but the judge is appearing biased. But if we don't know anything that got said back in chambers, whose word are we getting that from other than this guy who's the one who's mad about it? And I'll put it this way. I'm not saying he's wrong in merit or wrong overall, but I don't see so far anything in this where even a scintilla of responsibility is taken for how they ended up in this situation through the crime scene photographs coming out. There are going to be other things you'll see in these documents alluded to. So there were other bits of information being put out into the public by the defense team that the judge felt like was beyond the scope of what was allowable. So Baldwin, when he filed his motion saying, don't sanction me so much, Judge, and all that stuff, for his brief about sanctions and stuff, that had that balance to it. And of course, he had another lawyer come in and do that for him, but it had some balance to it. And I really wish that would have prevailed toward a decision in this thing. But on the other hand, if this is your attitude to the judge, is like, well, anything you do to us could hurt our clients, so you can't do anything to us. And we're not even going to talk about why you're mad at us, because that's really not important, because the only thing that matters is our client. Sometimes you don't persuade a judge by being like that. So I don't know. I can't really say there. The judge may be biased and the judge may not be. I can't take just their word for it. I would certainly rather see the transcript, right? That would be nice. So before I could say, but however, I hear what he's saying here. And some of these things, even if the judge is not biased and all that stuff, he still has some good arguments, like kicking us off of this case has these negative effects. I think that's a very solid argument. All of these truths weigh in favor of Richard Allen's choice to maintain Attorney Rozzi as a counsel record. And I agree. And since I think Rozzi was not the one who was involved in the photos getting out, there's less on him than the other one. So I hear all of that. All right, let's pump this one over to 10. Let's get up into this motion to disqualify. the judge, because that's where it goes straight at the judge here, which is, if you're an attorney on a case, if you have to do this, you have to do it. And he certainly feels like he has to do it. It ain't where you want to be. I mean, there's the old saying that a good lawyer knows the law, a great lawyer knows the judge. And so having a giant fight with a judge is not necessarily the best thing for your case. But if you got to have it, you got to have it. And he feels like he does. Is he fully justified, partially justified, or is he just failing to see the real reality of the situation? I can't say. I haven't seen the transcript of what happened. The judge certainly has enough power that she could have pushed these guys into a corner. Judge can do that. Whether she really did that or they just didn't like the situation that they were being put in, but they kind of got themselves into it and something had to come down on them, the judge felt like, to stop the behavior. I don't know the answer to that. This is just, as I said earlier, I think a bad result for this case overall. All right, motion to disqualify. Here it comes. The accused, that's Richard Allen, by his counsel, and respectfully, he does it respectfully, moves for recusal of and change of judge from Judge Francis Gull. So what has he got to say about that? Lots of things, it turns out. So the Rule 2.11 of the Rules of Judicial Conduct require a judge to disqualify herself when the judge's impartiality might reasonably be questioned, such as the case in this cause of action for the reasons described below. Now, that's not, you might appear impartial to people on Reddit or Twitter, because then we would never have any judge in any case, because on those kind of social media, anytime a judge does anything that goes against what the people already think the case should be, their side, that judge is horrible and terrible. So sometimes judges are horrible and terrible, but there's also a thing called a discretion of the judge. So the judge doesn't have a narrow lane to walk. They have a pretty wide lane, or else every case would be appealed all the time. And then also on top of that, if you don't really know everything that's going on and all of that, then your view of the judge being so terrible as to deserve being kicked off of the case, is not necessarily the best view. And there are a lot of prominent cases right now where people think judges should be kicked off and stuff. And it's a tough standard. And at first, it's pretty much up to the judge herself. All right, so they provide additional guidance. And the key word there is might reasonably be questioned. Depending on what happened in chambers there when the transcript comes out, and the judge is going to need to do some honest thinking about this herself. I'm not just pointing to the attorney here. The judge has to look at it and go, did I let things get so out of control in chambers in the last few weeks of this case that even if I recover now and bring a balance back to it, a reasonable person who evaluates the case could go, you weren't impartial in this case. The judge has to look at that. And I think you can't know that without knowing what was said in the transcript. I do not believe that prior to this brouhaha, that anything that happened in this case indicates that she wasn't going to be a fair judge just because she didn't move him out of the prison that he was in. That doesn't mean that. Now, having said that, I didn't think he should be in that prison. I thought he should have been in a closer jail. But that didn't mean that, in my opinion, that she wasn't able to be the judge on the case. But you may feel differently about it. But remember, there's a pretty wide avenue out there. Otherwise, you really wouldn't have a judge there. You just had a court of appeals doing everything. So, the law enforcement had press conferences for 6 years. Defense had one press release. The judge reacted strongly, and they aren't responsible for all the leaks. I agree with all that. I doubt they'd lie about what the judge knows. I'm not accusing them of that, but especially when you get mad, and he was mad when he came out of there, you can see things differently. So the judge might, for example, think I was being completely reasonable and only doing what was necessary to bring this case back in line, and has nothing personal against these attorneys. And then they perceive it as fatally compromising their handling of the case. And every once in a while, you'll see people get off the rails in a courtroom where they think the judge is doing something terrible, and then the judge gets ultra mad at that person because they're human beings too. And things don't go the way they should. And I guess that's what happened here. And whether it's enough for this judge to come off the case or not, we'll have to see. But generally speaking, I'm going to agree with you that I don't think there's something was going on to warrant them being pulled off of this case. Not that I've heard. Again, I don't know. I never read the transcript, but I'm aware of the allegations against the defense team. It's not anything that would have caused me to say you can't be on this case anymore. It might have caused me to do something to them, but it wouldn't have been that. And I think coming to the hearing and reading a statement and stuff like that, I don't know. I feel like why did the judge want to go to that, say, instead of just issuing a written order on it and saying, let's do this without cameras. I'm going to listen to it. And, you know, you can expect, I am not happy about this. I'm going to do something to you. And you do it writing, and it doesn't have the impact of a hearing that's all up on social media and stuff. So I don't know about that. I don't like the result. And when the results go bad, you know, the judge is in charge of the case. So she has some responsibility in that. Certainly, like, just to say here. So, all right, so let's move on under this. Judge Gold removed and concealed or allowed to be removed by the clerk of Carroll County defense pleadings from the chronological case summary in violation of the Indiana Supreme Court's administrative rules, including the Franks motion and memorandums and stuff. And they're basically saying, and they haven't hidden the state filings. Yeah, I don't know. I guess it depends, because I did not see the exhibits attached to all the Frank stuff, and whether that was something that the judge felt like you knew that should have been confidential and you didn't file it that way. And Rozzi has a lot of argument here about the procedure for things being confidential and stuff, but the judge might have felt like some of this stuff should have been filed under seal to begin with, and that might have been what was part of what was going to get discussed or has been discussed so far. So I see what he's saying here, but I think he's overblowing that to some degree, because some of that stuff shouldn't have been out there in the first place, probably. But and the judge has pretty wide discretion on handling this situation. So I don't know that one goes there, but it's also not his full and final argument. It's just the opening shot here that gets more into it. And this is kind of what I'm talking about, where Rule 2A provides in pertinent part, all persons have access to court records. So he's basically saying open court, we need to be able to file stuff and people need to be able to read it. And that is generally the way things should be. And I generally agree with that. Now, you know, depending on the circumstance of this case and what was in those exhibits, maybe it was appropriate what the judge did here, because the judge has a lot of authority. And I don't know. So I can't say. I think that'll be clarified later, probably. But he's saying none of the 13 grounds listed for excluding public access to records secreted from the docket apply in this case. So that could be true. The judge's opinion, obviously, perhaps different on October. And listen, I understand the criticism that, look, the prosecution got their free shots on publicity. They got to go out and talk about how we've arrested this guy, did it, and all of that. And then the defense team is almost immediately told to not talk anymore. So I get that. And that's why I agree with you. I would have a lot of leeway for them on that. Now, this is where we go back into the oddness and the yes-no-ist of this. You know, did this happen? Did it not happen? So he says on the 12th, the judge said, cease work on Mr. Allen's case, and that interfered with their attorney-client relationship and prejudiced them. And it was only a few days. So I think that's a little bit overblown, bringing the Constitution in if the judge is like, stop working on this case and for a little bit. But his point about, but I needed to be able to work on the hearings that you called. You're calling me to a hearing. You're compelling me to a hearing, but you're telling me not to prepare for the hearing. So if that happened, that seems weird. Is that really what happened? I can't say, but you know, it's a good point for him to bring out there, because that's interesting. So on the 19th, the judge conducted critical stage proceedings in chambers outside the presence of the accused, even though she'd ordered him transported, he was available. And she did the same thing after placing his attorneys in ethical dilemma, and again, creating public record outside the presence of the accused. Ignored clear precedent. It is all strange. I think it would have been better to exclude the cameras for this hearing if it was going to be all super sensitive and talk about leaks and things like that, and let Allen be in a courtroom and deal with your business. Maybe that wasn't the best time to have showtime for this case. On the 19th, the judge ambushed appointed counsel with a planned Hobson's choice to coerce withdrawals. The public shaming and be removed from the case or voluntarily withdraw. And that's, again, I'm not impressed by that. Sorry. They requested clarifications as to the topics in her motions to be addressed, which is certainly fair. She gave defense counsel no notice of her plan to force withdrawals and remove them, and denied them the opportunity to adequately refute her accusations. Now, that's an interesting thing to say, because didn't Baldwin's get an attorney, and that attorney appeared that morning and filed a brief? I mean, you just don't have that set in your briefcase. You had to write it up saying, don't take me off of this case. Don't sanction me. But if you do need to sanction me, just do this. And here's what actually happened. Wasn't all that done at the same time? I think. I thought so. So that you had to you knew what was up. I mean, come on. That same day, the judge had a prepared statement that she threatened to read to the public, alleging that they were grossly negligent. And that sounds ultra biased, right? But it kind of depends on what that statement said, I think. But he's pitching here that the judge should come off the case, so I get why he's doing it and what he's doing. She says her complaint was more about her not having control over counsel rather than legitimate concerns that they engaged in conduct. Well, that's reading the judge's mind there. Okay. Her complaint was more about not having control rather than any legitimate concerns. That's a complete conclusion. Okay. That's not a factual argument. That's just reading the judge's mind. She could read minds too, I guess, and everybody could just read minds in the courtroom, but I don't think that's how it works. Now, he tries to move back to the factual territory of saying, here's what the judge complained about, and here's our thoughts on that. And the press release, generic in substance, was issued by the defense in November, and only after repeated press conferences by prosecution. Intent was to level the playing field. Yeah, I think that's fair. And if she was mad about it, I don't think that was appropriate, assuming that she was mad about it. I mean, it's one thing to issue a gag order later, but, the defense was on the move at that point. That's their job, is to represent this guy, and they were calling it the magic bullet and stuff like that. And that's not persuasive to me, but I understand what they're trying to do is get some phrases out there to say, look, this case is far from proven. Okay, our guy's actually innocent, but the state has overblown what they even have against him. That's what they were doing. That seems reasonable. 2 motions filed by the defense, one which addressed the health and safety of defendant Allen, and second addressed immediate transfer. And that's about the Norse paganism, which is something that I'm working on. I'll have more details on that later, but we should have an epic video coming on that. It's delayed because of the level of research being done on this, and including in the area with other people, not just me. Anyway, they're still claiming that the Norse pagan people may not have only murdered 2 girls, but they were escorting defendant Allen around the prison. Individuals engaging in Norse paganistic practices may have not only murdered 2 girls, but were also escorting defendant Allen. So mentally, he's trying to link these 2 guards to whoever killed these 2 girls. Boy, is that a stretch there. Maybe not. Maybe you don't think so, but that's a wild stretch there. That's a wild one. Now, in terms of the wanting him transferred out of the prison, the first motion that they filed, I thought that had a lot of overblown, ridiculous arguments in it too. He's a prisoner of war and all that. But having said that, generally speaking, I bought into the things they said, that he's not convicted and he should be able to be closer to where he can actually participate in his defense under better circumstances. All those things made sense to me. And I would have tried to support them on that if I were the judge, but the judge herself didn't buy it. Now, in terms of their factual predicates, some of that was right up there with the he can't cross the creek stuff. So, and here's a good comment, I think here. Bottom line is, can Richard Allen get better representation? I think not, or I bet not. Yeah, I agree with that. Again, some of the stuff they've said is silly, but a lot of it is hard work that they're doing to try and advocate for this guy. And you got to respect that. If you buy everything they say, or if you buy none of it, that they're doing, they're invested in it, right? They are working hard on this. This is no public counsel who doesn't know his client's name and all the bad things you think about somebody when you imagine that. These are a little bit toward the other end of the spectrum. They're working hard on this thing. They're coming up with theories. They're pouring through all the old tips and evidence and how the police conducted the investigation. That's what they're supposed to do. All right, so more about the Odin stuff. You've had time to read that while you're listening to me talk about it. The Odinist connection was exposed. The defense had video of the patches, and the guards admitted they wore them. Previously noted a connection between the murders and Odinism. They also claimed there was an F on the tree, and it's not. The patches, I mean, it could be. It could be whatever you imagine it to be. If there's enough dots, you can connect them to think anything. But it is true that these guards were wearing these patches, and that's crazy, and it is what it is, and this topic we'll come back to. So they have that point going for them, absolutely. All right, so Baldwin had drafted an email to co-counsel. And this is, here's another one where wait, what actually happened here? What was in this email? Baldwin drafted an email to co-counsel, but sent it to the wrong person due to self-populating electronic email. That happens, right? I mean, who hasn't done that? So I hear that. On the other hand, what was in it, and that may advise a little bit the level of diligence that should have been expressed in it. The fact that you're sending an email is not an excuse for sending out, something that's super confidential to somebody who has no business seeing it. I don't know the circumstances around it, but it could be something that was like, dude, or not, right? Who knows? So I don't know, but I think that's an interesting one. The court alleged that Mr. Baldwin put improper statements in his Frank's memorandum, not false or misleading, but improper. I don't know what all, he's saying the court alleged that. I don't know which parts of it she didn't like, but I'm going back to the creek for this comment down here. It is an impressive, this is what they say about their own writing. It is an impressive piece of legal writing that has been lauded by expert defense counsel across the nation. They filed a supplement for that. It was like 130 pages long. But after that, they filed another supplement because they felt like they didn't really discuss the actual legal burden appropriately in the original filing. So if you have something that should be lauded, maybe, and it's for a specific legal thing, like throw out this search warrant and here are the 2 Frank's factors, maybe get both of those Frank factors in your original 130 some pages before you put it up for a book prize. So again, he's an advocate and he doesn't mind advocating for the guy who was writing this, Baldwin, I suppose, and that's okay. But again, when you read this stuff, you just got to throw a lot of it out, and that's true on any kind of legal filings that you have, and also true on the prosecution, their state side often as well. But that one is right up there with the 5'4" guy can't cross the creek, but little teenage girls can. Is lauded by expert defense counsel. That may say something about that group more than it does about that document. Rozzi had filed a tort claim notice to preserve the rights of his client. I don't think I knew that before this. The court opined this action amounted to gross negligence. So I don't know how that's negligent, and I didn't even know that it happened. Filing a notice was intended to preserve the rights of the man who was shuttled off to one of the most secure detention units in the state, locked up, isolated with only a tablet, no ability to speak with his wife in private. So how can you confess to the crime if you can't talk to your wife in private? Because there's an allegation that he did that, and it's not even disputed that he said some inculpatory things. That could be a wide range of things, and I think that's really interesting because his wife continues to show up in court on his own behalf. So it makes me wonder, what did he say and what was the context of it? Anyway, that's what they have to say about this. That the judge was mad because Mr. Baldwin hired a lawyer to represent him in this matter. This was not true. Mr. Baldwin was betrayed by a friend, and there was a subsequent related suicide. As a friend and colleague, David Hennessy suggested he needed a lawyer to speak on his behalf, and he volunteered. No fee was arranged between the two. It's very fair, and that rings true to me for sure. The court also alleged undersigned had put volatile facts in the memorandum regarding possible sanctions or disqualification. The true facts in a criminal case are often volatile. There is no untruth. Okay, well, that is true. It is often volatile. I think it was interesting because that's not how you normally see something occur, even if you're facing a sanction that some third-party lawyer comes into the case to deal with that for you. You just deal with it with a judge. But having said that, when the guy appeared in the brief that he wrote, I thought it was a measured brief and had a couple of extravagances in it, I think, purloined and some bamboozled or whatever and snookered and things like that. Some street lawyering kind of language. But in the end, it was a balanced approach to the judge that, listen, this shouldn't have happened. Okay, this should not have happened. This was a breach of trust, but we're on it. We're taking all these additional steps. Keep in mind, this is about getting somebody to trial, and getting him to trial as timely as you can is good and fair for that person and for the victims, right? And then their families. So if you need to sanction somebody, don't punish the client who had no control over this. Punish me, make me work for free for X period of time. I thought it was a good brief, and it's the kind of balance that you'd want to bring as like a practical solution to the judge. It's very unfortunate. I think something couldn't get worked out. So while it's unusual for them to have another lawyer come in like that, I thought he did a pretty good job. The dissemination leak of crime scene photographs, neither Rozzi or Baldwin had knowledge or participated in. I think we know the things about that, but the judge being mad about that is fine. I mean, the fact you didn't know that your unsecured, super confidential discovery got taken by somebody in your office is not necessarily going to have her go, well, hey, it happens to all of us. But it can happen, right? But you also have a responsibility there. I think the question is not whether it's bad or not, and maybe whether you're, especially if it's a pattern of things, pay some kind of price for that. But it's really what was the judge's ultimate response for that. And I don't know that because we don't have that transcript yet. Everything cited by Judge Gull as concerning was either not attributable to Rozzi or excellent in ethical lawyering in the best interest of the client's defense and mental and physical well-being. Now, here he does say it's not attributable to Rozzi. Okay, because he's leaving Baldwin out there. So if there was a leak, it came out of Baldwin's office, and Baldwin wrote the email that got to the wrong person. So I hear what he's saying there. And so I guess in theory, maybe you'd want to bust hard on Baldwin, but not Rozzi so much. And that's a fair distinction there, probably. Throughout the pendency of this proceeding, the defense has exposed untruths by law enforcement, withholding of exculpatory evidence by the prosecution, and discovery violations about which Judge Gold showed no concern and did nothing. Is issuing the order that you requested for all discovery to be turned over, I forget the date, but I think it was the beginning of November, as you requested, doing nothing? Again, I think this is one of the issues here is if you overblow your own position too far, if you got fans out there, they're going to look over that. But if you have somebody scrutinizing what you're doing and you're like, that's not how that happened, and this isn't how that happened, and this isn't how that happened, it can start to take away from some of your core points where you might have better arguments. Because nothing is not the same as didn't do everything that I wanted her to do. Those are all different things there. And you hadn't even got to the Franks hearing yet, and you did bust the judge with a lot of documents to read to get ready for that. So the court has routinely expressed umbrage at defense counsel's representations through investigation and filings, while silently abiding in prosecution's discovery delays and false statements. Maybe. I don't know how much umbrage she's expressed because I haven't been hearing her talk to them. But here's the big one. Judge Gold coerced an oral request to withdraw from Rozzi. So he did an oral request to withdraw, he's saying, but he's saying, you made me do it. And he's already made that argument, right? And the same thing from Baldwin. Now, Baldwin's not on this motion to let me back in this case, which is quite interesting. It's just Rozzi at this point. And maybe if they get the judge booted out, he'd want to come back in or something like that. But they're conceding they made oral request to withdraw. They're just saying that they were given two choices, and one was so bad that this was the only one they had left. If you got two choices, guess what? You got two choices, and you didn't like the one where she was going to scold you and throw you off the case. And I understand that, but you still could have forced her into that position to do it. Now, that's not to say she should have forced you into position of saying you either quit the case now or I'm going to do this. I kind of feel like that wasn't too good either. I mean, at some point, get on the record and hey, just handle the motions. And if it's there's too much publicity, kick the people out of the courtroom and just do the business. So let's see here. As previously stated, Judge Gold strong-armed them with a prepared statement that she intended to read into the record. It's fair for her to have a prepared statement. I mean, judges have orders ready all the time. If you notice in these sentencing things, you have the hearing and people talk and all that, and then the judge reads off the sentence and they're reading a piece of paper that they already have. So in theory, they still have to think about and consider all the things that are being said there. It doesn't mean you have to come into it blind and with nothing ready to go. So from whatever she had seen, heard, knew about, et cetera, she had made her notes about what she was going to do. So that may sound worse than in my opinion, it is. It all depends on what was in this prepared statement. Within minutes, she took the bench. Within minutes, Judge Gold took the bench, started the record, and informed those present and viewing public there existed an unexpected turn of events, defense team withdrawing from the case, which was true. By their admission, they withdrew from the case. That's in all these documents. He's just saying we shouldn't have had to do that, and I now take it back. The only clarity offered up by these statements is that they were entirely inconsistent with her actions in chambers just minutes earlier that forced the attorneys to consider withdrawal in this matter. They run afoul of 2.1 as they demonstrate the tribunal's lack of integrity and impartiality. That's a big word to throw down on a judge right there. Is you're not even saying, Judge, I think, what's happened in this case could cause a reasonable person to think you're not impartial. And maybe it's the personality conflict we have, or maybe it isn't, or whatever. But here's why I think that, or here's why I feel like you're partial. The words lack of integrity is a big one, because you're not just slanted towards one side. You have a lack of integrity toward the public, and you usurp his right to competent legal representation. So that is throwing down there. That is putting a grenade there. I don't know these people and where they practice and how often they appear in front of the same judges and who knows who and all that, but that's big words to use there. You should always be willing to use them if you have to on behalf of your client, but it's no small thing. All right. So I think that's all of these documents. So let's see. short version of this again is the judge issued some rulings, and then part of what she said was that they withdrew out of the case, take them off the record. Let's bring Allen in on 31st. We'll get him a new lawyer. And then Rozzi steps back into the game and says, I'm not leaving the case. I'm staying on the case. I want you disqualified from this case. Okay, so judge, take yourself off of this case. And if you don't, I'm sure he's planning on doing something about that. And then further delay any further hearings or anything like that, any decisions on anything else until we get this matter resolved about you being taken off of this case and another judge coming in. So that's what's going on right now. Allegations that she's shown a lack of integrity and other things like that. So I think he's got some good points on the harm that happens to his client, obviously, from losing the lawyers that he's got. Even if they weren't that good, if you switch them off of the case, you're going to delay the case. But they also have been trying very hard on his behalf, and we're pretty close to trial. So losing his lawyer is bad. And the real weight of his statements about what the judge said and whether it leaves out maybe key things that have happened, key things that he said or Baldwin said or other things like that, I don't know that. And maybe if you do, I don't know how you do, because the transcript's not out there yet. He did say there was a recording of it, and there is an order for transcript, and certainly that can't just be the 2 minutes when she was on the bench. So I would think with all of this happening, you'd want to transcribe what happened there, I would think. And at least, now again, here, if you have to make findings of fact, if you have to judge whether this happened or not, then in this state, at least you want another judge doing that. If you take all the allegations as true and it's still legally insufficient, then you don't move the judge off the case, because you can't have people kicking judges off the case all the time whenever they feel like it, they're not getting their way. As I say on social media, that would be a judge coming off of every single case, because everybody thinks all judges are crooked. It's just a matter of which judges do you think are crooked when, depends on which case you're looking at. So let's see what I missed here. Let's see. Yeah, there's a little bit of a discussion of privacy there. So yeah, I'm sure on his tablet, it probably says when you log into it, we're going to record and listen to everything you say. And it probably beeps when he's doing it and all that stuff. What he actually said, I just don't know. But it certainly, I think, was inculpatory, because even his own attorneys haven't argued against that. They're just arguing against his mental state when he did it. But how much, I don't know, because his wife keeps showing up. So I have some theories of what he might have said, but it's just imagining things based on trying to interpret people's behavior. So that's not worth anything. You could get a magic 8-ball to give you better information than that. And you're not late, you're early before the end of it. So there may be some more come out about this by the weekly docket over the weekend, but I don't know. This is a whole lot to drop in one day on this case. So I thought, well, why not take a look at it? Every call in jail is recorded, and this was on a tablet. So I think that's what that is. And he's not going to get that kicked out because of any kind of privacy right. And I don't think he'll get it kicked out because he was crazy. And even his own attorney said that the jury will have to deal with that. So that part hasn't been leaked out yet, right? And if so, what did he say? Although I think it was the state who brought up in open court that he did make inculpatory statements. So, I kind of see a little bit of what the defense is saying is, we want more of this case in the public, more of this evidence in the public. Now, that's not defending the crime scene photos being leaked. I don't think they should have the ability to do that. But in terms of their arguments, the facts and the general evidence, not the graphic evidence, the public should know, unless there's a compelling reason not to, what is going on in a case. And one compelling reason, of course, can be tainting the jury. So that's part of it. But anyway, that's what I got on it, and I appreciate everybody stopping by to catch this stream. A lot of documents there, but I try to do it a short version at the front end and the back end, and we'll see what the judge does when she takes this up. I don't think she's going to want to drop that October 31st date, so maybe they'll do this then. It'd be very interesting to see how she handles this situation. All right, that's it. Thanks, and bye.